Hi, everyone. I'm Eric Buchanan. I'm the president and owner of Eric Buchanan and Associates. We're a law firm that helps people all over the United States who have been denied long-term disability insurance benefits, health insurance benefits from large claims, life insurance benefits, pension benefits, especially those based on disability or long-term care policies. We especially help people who have been denied benefits covered under a federal law called ERISA, the Employee Retirement Income Security Act of 1974. Now, before I get into the story today, I want to tell you about the math on these ERISA benefits and how likely people are to succeed if their cases go to court. A little bit about our firm. We help people all over the United States. We have clients all over the country. We work with local attorneys in the states where we're not licensed, so you can look on our website and see where we're licensed. But understand, anywhere in the United States, we'd be glad to help you with your case. We're a niche law firm that works with people all over, so we can find a local attorney or already have a relationship with a local attorney in the state where you're located to work with us locally and bring our experience in ERISA and disability insurance to the table. So if you have any questions about that, check us out on the World Wide Web at buchanandisability.com. Now let me get into the topic I'd like to talk to you about today. ERISA, the federal law that actually is called the Employee Retirement Income Security Act of 1974, was passed in the 1970s in order to protect employee benefits, to ensure that people who are denied pension benefits or denied insurance benefits that they get through work, like long-term disability or health insurance or life insurance, that there's a federal law that would provide, originally the idea was extra protection for employees. And unfortunately, over the years, that's been translated by courts into a system that I think is not as fair to employees as it is to the insurance companies and the employers. And there's lots of reasons for that. We've talked about in other podcasts. And just a few examples are that the federal courts, especially the Supreme Court, have said that insurance companies can be entitled to a deferential standard of review if they write their policies correctly, that if a employer or an insurance company puts in the policy that the insurance company has discretion, then the insurance company will get the benefit of doubt in court. There's other rules in ERISA, such as that you don't get a jury trial, that the court reviews the claim only based on a closed file, so you have to submit all your information to the insurance company early on. There's very limited discovery in ERISA cases. There's some discovery into the conflict of interest, but not much into the merits of the case. So in other words, you can't go get more witnesses to testify in court about how disabled you are if the insurance company is denying your long-term disability benefits. And one of the downsides of all this is that a case that goes to court, an attorney handling that case really needs to understand ERISA in order to give his or her client the best shot at winning the case. And even an attorney who understands these cases and knows how to handle them properly under the ERISA rules is going to struggle to win a majority of their cases sometimes. The statistics are just not that great. And so let's talk for just a quick second about how pervasive ERISA is. ERISA applies, once again, if you have long-term disability insurance through work, life insurance through work, health insurance through work. And I have an article here from the American Bar Association's Journal of Labor and Employment Law, written by Sean Anderson. It's called ERISA Benefits Litigation, an Empirical Picture. And one of the things that it tells us is that 31% of the people who work have a long-term disability plan that's typically covered by ERISA. 52% of the people who work have a health insurance plan that's typically covered by ERISA, and 57% of people at work have a life insurance plan that's covered by ERISA, and about 50% of people have a pension plan covered by ERISA. That means a lot of working people have either their retirement benefits, their life insurance benefits, or their disability benefits, and their health insurance benefits, all of those things covered under this federal law called ERISA, the Employee Retirement Income Security Act. Well, if everything works great and you die and your family gets the money under your life insurance policy, that's great. But what if the insurance company decides for some reason they're not going to pay the claim? They're going to decide that you didn't have proper coverage, that you should have done something differently early on, that you maybe were engaged in some illegal activity when you died, even if you really weren't. Those kind of claims, issues come up all the time. The insurance companies fight over health and life insurance claims. Health insurance claims, when this law was passed, it was normal for health insurance companies just to pay almost every time a doctor said something was medically necessary. Well, here we are 50 years later, and insurance companies have come up with lots of ways to save money on health insurance claims. They get their own doctors to review claims to say stuff is not medically necessary. They dispute whether something is the best medical service for you. They dispute whether or not the evidence supports the type of medical treatment that your doctor thinks you should have. So a lot of health insurance claims are denied. And long-term disability claims especially are frequently subject to litigation, and their denial, and then they end up in court because insurance companies deny long-term disability a lot of the time because it's hard to prove just how disabled you are. You might be unable to work because you have a pain or fatigue, a health condition that causes those things, but how do you prove just how fatigued you are? How do you prove how much pain you're in? Those things can be very difficult, and courts end up having to look at this fight that the insurance company puts up of not wanting to pay because insurance company claims, for example, you don't have sufficient objective evidence that you're disabled, or that their doctors say that what's wrong with you is not enough to be disabled. There's lots of reasons the insurance companies can deny these claims. And when the insurance companies deny the claims, what happens next? We have to go through an appeal process. Under ERISA, one of the things that it requires is that you have to what's called exhaust your administrative remedies. Well, what does that mean in plain English? Well, that means that you have to do an appeal through the insurance company's process to submit the information that you think would help win the claim and give the insurance company at least one more chance to deny your claim. If the insurance company denies the claim again, then the case can end up going to court. Well, when these cases go to court, one of the things this article talks about, and once again, this article is called The ERISA Benefits Litigation, an Empirical Picture by Sean M. Anderson. It was published in 2012, and I know that's a little old. I'd love to talk about some updated information related to this, but I think the numbers in here are pretty consistent with what we've still seen today, and I'll talk about some changes over time. But once again, Sean M. Anderson, ERISA Benefits Litigation, Empirical Picture from the ABA Journal of Labor and Employment Law. He talks about what he and I think it was some law students did was they did a lot of research into how often people win long-term disability cases when their case goes to court, how many people file these ERISA cases, that kind of stuff. One of the most shocking statistics to me was that of the cases that end up being denied by the insurance company and taken to court in the first place, 24% of them, which is basically a quarter, 1 in 4 insurance cases against a company where the policy is covered by ERISA is filed in state court claiming that state law applies. Now, maybe there's a few smart attorneys out there that are trying to sneak that in to see if the insurance company will dispute and agree that ERISA is not applicable. Insurance companies know better. They know when their policies are covered by ERISA. And I suspect, having read between the lines of this article and just based on my experience of handling these kind of cases for more than 25 years now, that a lot of attorneys just don't know that ERISA applies to these type of policies, that they don't know that the ERISA applies to these insurance policies, and that when people file these cases, when attorneys file these cases in court, in state court, and they don't claim ERISA applies, well, that means they probably didn't know how to handle an ERISA case. They may not have developed the record as much as should have been done. They may not understand that they can't present new evidence once the case goes to court. I can't say for sure in every case, but based on my experience, that mistake happens a lot of the time. If a case is filed in state court, the attorney's already not handled the case well, has already mishandled the case in a way that's going to make it awfully hard to win under ERISA's rules in federal court. And according to this law review article, 24% of the time, almost 1 in 4 cases are filed in state court. So that tells you about a fourth of the time it's going to be a big uphill battle for the person who is hoping to win their case in court. Another part of this study is that the author and his assistants went back and they looked at the cases that actually went to court, and he focused largely on the long-term disability cases, and he did it for, I think, a block of 4 years, and he picked out representative cases from that time period, selected through several hundred cases to do a full study. And one of the things that he noticed is that if the attorney acting on behalf of the client sued under ERISA and alleged that the policy was subject to de novo review, which means his attorney is claiming that the arbitrary and capricious language is not in there, that the insurance company should not get deference. The attorney was willing to at least make that argument. That means the attorney handling the case understood ERISA well enough to make that basic argument that they shouldn't automatically have the policy and the claim subject to this deferential standard review, giving the insurance company a little bit less chance of winning in a certain percentage of these cases. And that increased the person's chance of winning if the case went to a final decision by the court. Another thing that attorneys might do that would give a better chance of winning is asserting that there's a conflict of interest. So one of the things that courts have said over time is that if an insurance company has deference, and so it's subject to an arbitrary and capricious standard review, the Supreme Court has held in a case called Metropolitan Life versus Glenn that the courts should take into account how that conflict of interest affected the claim and reduce the amount of deference given to the insurance company in some way, taking into account that conflict of interest. And we can get into those details in a different podcast of how that actually works. The point being that if your attorney understands ERISA, your attorney is, if at all possible, going to make at least one of these two arguments: that a case is subject to a de novo review, or that there's a conflict of interest. It's rare that you can't make at least one of those two arguments, but apparently attorneys are not always making those arguments. Well, what ends up happening when these cases get to court? The insurance company has denied the claim, and the person finds an attorney, and that's already selected out a bunch of people. So there's some people that don't find an attorney and they give up. But out of the cases that go to court, it turns out that the most cases to settle in court are cases where the attorney failed to argue either for a de novo standard review or that there was a conflict of interest. That's over 80% of the time. That's 4 out of 5 cases that go to court. If the attorney fails to make that argument, they're probably going to end up having to settle the case in a way that's maybe not to the best advantage of their client. I don't know for sure exactly that, but that might be something I'm reading into it. But then here's the bad news from this report. That means that only a certain percentage of these cases actually go to judgment. Now, some cases are dismissed for other reasons. Some cases are remanded back to state court for certain reasons, that kind of stuff. But of the approximately 10% of cases that go to judgment, so over 80% settle, 8 or 9% get resolved on other means, 7.4% are denied, and only 1.9% are paid. Now, if you round that off, that basically means that if the person doesn't settle and the court decides their case, they have an 80% chance of losing and a 20% chance of winning. That means they only have a 1 in 5% chance of winning their case if they go to judgment and their attorney failed to argue for a conflict of interest or de novo standard review. If the attorney does argue for one of those things, the person's chances of winning, if their case doesn't settle, goes up a little. It doesn't go up to a tremendous number. It only goes up to 27% chance of winning and a 73% chance of losing. Now, what do these numbers mean in plain English? It means if your case goes to court in an ERISA case and you just have the average numbers apply, then you have only about a 3 in 10 chance of winning at best if your attorney does argue for a conflict of interest or de novo standard review, and only about a 2 in 10 or 1 in 5 chance of winning if your attorney doesn't argue for either of those things. Now, I can't guarantee if you're listening to this that your particular case would have a better chance. I can't give anybody specific advice on this, but I can suggest that attorneys who regularly handle these ERISA cases, like we do, can do stuff that give you a better chance of winning, or give you good advice on when you should settle your case to your best advantage. But part of what I hope people understand from this is because of the standard of review in these ERISA cases, because of all the rules in favor of the insurance company, even when an attorney knows a little bit about ERISA, the chances of winning the case are still better for the insurance company statistically than they are for the person who's making the claim. And in some cases, it can make a big statistical difference. If you have any questions about that and you want to talk to a law firm that's handled a lot of these cases and we can talk about how your case looks, then please reach out to us at buchanandisability.com or call us at 877-634-2506. I'd love to talk to you more about your case, or have one of the attorneys here that helps people all over the United States with disability cases, and explain to you in your case whether we can give you a better chance of winning than just the average out there. But just be aware, if you have a case subject to ERISA, according to this law review article, the numbers are pretty bad. Now, what's some good news? Well, over the time, first the Obama administration and then the Trump administration combined put out a set of regulations that apply to these claims that should give you a better chance of having de novo review. It makes it a little bit more likely to have that review if the insurance company doesn't handle your claim fairly. And so one of the things we'd like to do is get some updated statistics on that, and we're working on that. We'll talk about it in the future podcast. But in the meantime, just beware of these basic statistics. If you have an ERISA case and you don't hire a law firm that really understands how it works and has been doing it for a long time, the overall statistics in these cases are pretty scary. Pretty scary for people who are trying to win a claim for benefits. So if you have any other questions about this, once again, please reach out to us at buchanandisability.com or call us at 877-634-2506. We'd love to help you if we can. If you have been denied long-term disability, disability insurance, health insurance claim that's a large one, any kind of long-term care claim, or also any kind of a life insurance claim. Thanks for listening today. I hope you learned something.